presentation that I'm doing is on HIPAA as confidentiality. It's on HIPAA 42 CFR Part 2 and then protected health information. So next slide, Kara. So in the substance abuse and mental health field, confidentiality is governed by federal law and regulations that outline under what limited circumstances information about the client's treatment may be disclosed with and without the client's consent, which falls underneath the HIPAA and the 42 CFR. Next slide, Kara. So protected health information is any information in a medical record that can be used to identify an individual and that was created, used, or disclosed in the course of providing a healthcare service such as diagnosis or treatment. Any identifying information that relates to an individual's past, present, or future physical or mental health condition. The Privacy Rule Act protects any individually identifiable health information held or transmitted by a covered entity or its business associate in any form or media, whether electronic, paper, or oral. So individually identifiable health information is information including demographic data that relates to the individual's past, present, or future, the provision of the health care to the individual, or the past, present, or future payment for the provision of the health care or the individual, and that identifies the individual or for which there is a reasonable basis to believe it can be used to identify the individual. So next slide, Kara. So individual identified information is what's listed. It's the name, address, social security number, any element of a date, birth, admit, discharge, or death, name of relatives, telephone, fax, or other numbers, email addresses, geographic destinations like your state, and a photograph. The HIPAA Privacy Policy Rule sets forth policies to protect all individually identifiable health information that is held or transmitted. These are the HIPAA identifiers that are considered personal identifiable information. Next slide, Kara. So the Privacy Rule Act went into effect in 1996. It was endorsed by the U.S. Congress. It establishes national standards to protect individuals, medical and electronic personal information records, and other personal health information that is created, received, used, or maintained by a covered entity, which would be us. It applies to health plans, healthcare clearinghouses, and those healthcare providers that conduct certain healthcare transactions electronically. Next slide. So the security rule requires appropriate administrative, physical, and technical safeguards to ensure the confidentiality, integrity, and security of electronic protected health information, which would be our credible system, is where we store all of our healthcare information. And let's see. Okay. So next slide. So HIPAA provides the privacy of patients and ensures patients' data is appropriately secured. It requires individuals to be notified of a breach in their healthcare information. And so if any time a system is hacked or there's a breach in the information, everybody that's involved in that system has to be notified. Several years ago, I think it was the University of Utah, they had a breach. And so anybody who had any services between a certain period of time had to be notified that their healthcare information may have been compromised. There are restrictions on allowable uses and disclosures of protected health information, stipulating when, with whom, and under what circumstance healthcare information can be shared. And ensure electronic health data is appropriately secured. Access to electronic health data is secured, and access to electronic health information is controlled, and an audible trail of the activity is maintained. So with Credible, the way that Four Corners has that is that there's little footprints. So every chart that anybody goes into or anything that anybody does within the Credible system, there's an electronic footprint that can go back and be audited. Next slide. And so HIPAA gives individuals the following rights. They have the right to receive a notice of privacy practices, which we give out in the intake information, informing them on how the provider may use and disclose their health information and accounting of disclosures. So anytime we give that information out, we have to have a trail of where it goes. They have the right to access, inspect, and receive copies of their health information. So they have to request that through a GRAMA request. There's grounds for denial. So if there's reasonably likely to endanger the life or physical safety of the individual or another person or cause substantial harm to another person mentioned in the health records, we would deny that access. So if somebody's talking about, like, there's a domestic violence situation and there's a release of information for a spouse who may be the perpetrator of that abuse, and we feel like it would put our client at risk, we can deny the request to provide that information. They have the right to correct the record by adding supplemental information. Like if they go through and they feel like things aren't accurate, they can add their information to make it accurate. They have the right to request restriction on use or disclosure of information, and they have the right to revoke authorization at any time. So if, like with our releases, there's check boxes of different information that we can disclose, UAs, assessments, things like that. And so if somebody is working with another agency and they sign a release of information to provide that information to the other agency, the only things we're allowed to provide to that agency is just what they checked. Like if it's only assessments, we only provide assessments. If it's diagnosis, we only provide diagnosis. We only give what they say that they want released. And so we have to be really careful with releasing information to other entities, because we want to make sure that the release is in place, it's accurate, and we're only providing information that the client is saying that it's okay to provide. So if requested, the agency must give an accounting to the individual for every time their protective health information is released, for purposes other than treatment, payment, and healthcare operations. So HIPAA provides it so we can bill insurances, things like that. It covers us so we can provide that information to insurances to pay for it. There is a release of information that goes out with the intake. We get the client on being able to provide that information to their insurances. There are some exceptions, and then we'll kind of talk about that. So requests to see protected health information about an individual must be fulfilled within 30 days and within 60 days with a written extension. The protected health information held elsewhere or with a business associate and limited to designated records, or the organization requested must notify the individual and redirect them to where they might find the information if known. So if somebody calls like another agency like DCFS or AP&P and they have a copy of the assessment and there's releases in place, they still can't release that document to that person because that document belongs to Four Corners, and so they would have to come through us. Requests for amendments must be fulfilled within 60 days. And individuals have the right to request restrictions for any use described. Organizations do not have to approve requests, but a procedure for handling requests for restrictions should be documented. An individual may request confidential communications or their protected health information by alternate means or alternate location when disclosed. Other protected health information that could endanger them. Also, state law may allow the specific confidential communications for minors. And so the terms of an organization's privacy practices is communicated to an individual through the notice of privacy practices, which we also give out in the intake information. They have the right to deny access as well. It's important to document the client's refusal to do so. So if they don't want to release information, they have the right to say, no, I don't want to release that. Individuals have a right to request restrictions for any use described, and organizations do not have to approve requests, but a procedure for handling the request for restrictions should be documented. And let's see. Next slide. And so Four Corners falls underneath we fall under HIPAA, but we also fall underneath the 42 Code of Federal Regulations, which is the 42 CFR Part 2. This is a federal confidentiality, and it's more strict than HIPAA. So because the code is more strict, we have to follow the strictest regulations. So Title 42 is a principal set of rules and regulations issued by the federal government regarding federal help. The purpose is to ensure that the patient receiving treatment for substance use disorder in a Part 2 program is not made more vulnerable than an individual with a substance use disorder who does not seek treatment. Next slide. So why is 42 CFR Part 2 so important to people living with substance use disorders? So confidentiality is a cornerstone of any treatment relationship. For people receiving substance use treatment, strict confidentiality protections means that you can share information about past and current drug use without worrying that will be used against you by the police, landlord, employer, judge, or social worker. Does anybody have any questions so far? Okay, next slide. So Part 2 requires a patient's written consent before making the disclosure of protected records. So patient consent must always be written and include specific information about the recipient of the records and the records to be shared. So with our releases of information, they're two-way releases. And so as you fill them out, if anybody, I'm sure everybody's seen them, and it talks about what's going to be disclosed and to who, and what can be disclosed to us, and for what reason. In the bottom, there's check marks of why that information is going to be disclosed. All of those boxes have to be filled and to make the release of information put it in place, I guess. It makes it valid. If those things are not filled out, or there's not a witness signature, or there's not a client signature, the release of information is invalid and does not protect you when you release information if all those things aren't filled out. So what I do in the Price Clinic is I try to make sure that I stress to my clinicians that when they're releasing information, that they make sure that they check the releases, because not all the time do the clinicians fill those out. Sometimes the support staff will fill those out, or other agencies will fill them out and send them, and then they get uploaded. But you always want to be checking to make sure that the information that you're releasing is the information that the client is saying that it's okay to release. If you release information that is not checked or saying it's okay, then then you can be in violation of releasing confidential information. Does anybody have any questions about that so far? Okay, next slide. So HIPAA versus 42 CFR, both Part 2 and HIPAA protect patient privacy by regulating the way that patient information can be shared and disclosed. HIPAA applies to many types of patient information, not just substance use information, and generally is less protective of patients' privacy than Part 2. Part 2's privacy protections follows the records even after they are disclosed. So the recipient of the record is also bound by Part 2's privacy and security requirements. So there's been times where, so with releases of information, like with DCFS, there's a lot of entities that get involved when there's child welfare cases. There's the courts, there's the guardian ad litem, there's the attorney general, there's DCFS, there may be other attorneys involved in those cases. There has to be a separate release of information for each one of those entities. You can't just release it like to DCFS and then not, because they are in violation. If they release it to the court without a release by the client, they're in violation of confidentiality for 42 CFR. So they are also required to follow those 42 CFR regulations. And so I try to educate when I'm working with DCFS and those kinds of things, because sometimes I don't think they understand. Because I worked for DCFS for 20 years and we only follow like the HIPAA stuff. We weren't underneath the 42 CFR. And so they don't always understand that confidentiality. So I always try to educate other entities about that. So because if they're releasing that information, it's still our document and they can't release that to somebody else without a release of information. Does anybody have any questions about that? Okay, next slide. It's easier than you think to breach client privacy. When was the last time you threw out a sticky note with a message or reminder on it? Did it have a name or a number on? What was the last time you took a work call with your friends or family nearby? What did they hear? The last email you responded to, did it have a name on it? Some of the most common complaints from our clients are exactly this: emails with clients' information, overhearing a conversation through an open door, client information being seen on a desk or in the trash, and releasing information before checking to see if there's a release in place. Overall, I think we do really well as a company. However, we all have room to improve. And if we each do our part, our company will be better for it. So it's our legal and ethical responsibility to keep client information secure. Next slide, Kara. So releases of information, we are unable to release any information to anyone regarding any client in any program without a release of specific information signed by the client. Anyone requesting client-patient information must have a specific reason for the information, and the disclosure should be limited to the specific request for the specific purpose. So sometimes we'll have clients that are 18 or 19 that still live at home, and their parents will call and say, hey, does this person have an appointment? Unless there's a specific release in place for that parent, we can't even disclose or even give the idea that that person is even a client without a release of information. So if people call and they want information and you're not really sure how to respond to it, I would talk with your directors or any supervisors so you kind of know how to respond to those. If somebody calls and there's not a release, just be very, very general in your communication. For example, based on this is generally how we treat this type of circumstance. You're not giving any specific information about a specific person. You don't even want to allude to the fact that that person is a client to anybody who calls without a release of information. If somebody calls and there is a release, you want to be able to verify who that person is to make sure you're releasing information to the right people, because I don't think it's unheard of that somebody would call and say, I'm so-and-so, and say that they're the client, or somebody that's on a release and say, will you give me this information? And if we don't verify who that person is on the other side of the phone, then we could be in violation of confidentiality. So you always want to verify who that is by birth dates or social security numbers that they tell you or things like that, so you can verify who they are. Next slide. So exceptions for releasing info without an ROI. There are some exceptions of releasing information about client-patient information without attaining a release of information. So do you guys know what the exceptions would be?
Mandated report.
Did you catch that?
I'm sorry, say that again.
I said a mandated report.
And what does that mean?
So if there was abuse, if they were a danger to themselves, a danger to others.
Yes. So child abuse investigations, if there's a disclosure of abuse or neglect, everybody in the state of Utah is a mandated reporter. Failure to report that, it's like a class C, I think, misdemeanor or something. People can be criminally charged if they know that there's abuse and they fail to report it to the Division of Child and Family Services. Sometimes it doesn't reach the level to be able to disclose that information. And so if anytime you have a client that you're working with that discloses that information, I would definitely run it past your director, or you can call me and say, is this something that I can breach confidentiality for? Because there's some disclosures that really wouldn't rise to the level where you can breach it, but there's some that there are. So you always want to get a second opinion before you just call and release that information. And so, yes, for the health and safety of others, if somebody's suicidal and you're having to do a safety plan with a family member, a spouse, or something like that, you are able to breach the confidentiality for that. However, when I'm doing safety plans with clients, just to kind of save some heartache on the backside, when I call the person or talk to the person I'm doing the safety plan, I make sure the client's in the room. I always ask them if it's okay if I call them or talk to them. I make sure the client's there. I let the person know that the client's there if it's a phone call. And I put them on speakers so they can hear everything that I'm saying. And then I also let the other person know that right now I'm able to give you this information because there is a safety concern. But once the risk is over, I will no longer be able to give you additional information or even verify that this person's a client without a release. So I always try to tell them on the front end, because sometimes they'll call and they'll say, hey, tell me how things are going, what's going on. And you are unable to tell them that information because the crisis is over. And they may get frustrated and say, well, you told me before. So I always tell them on the front end. So then that way there's no question when the crisis is over. And if they want to know additional information. Next slide. So there are limited exceptions when providers can make disclosures without a written consent. Is internal communication. So within other agencies like Operation Recovery can talk to the Carbon Clinic, the Emory Clinic, the Moab Clinic, those kinds of things. Medical emergencies, like if somebody's having a heart attack or a seizure, you obviously can call the ambulance. Reports of alleged child abuse or neglect. Reports of a crime on program premises or against program personnel. So if somebody's in one of your rooms and they're destroying stuff, punching holes in the walls, that you can call the police to come and handle those things. Or immediate threats of health or safety of an individual or the public. Sometimes, like if sometimes the police are looking for somebody and they come into our programs and they're in our building. If the police walk in and they want to know if a client's there, we are still unable to release that information to them because they're protected. And so if that ever happens, we don't want to just say, I'm not telling you anything, you have to leave. You always want to try to kind of explain the confidentiality. Most of law enforcement understand that, but sometimes when they're new, they don't. And so you want to kind of explain those things so that they understand that you're just not withholding information just to withhold it. If they want to talk to your director or somebody else, then I would have somebody else come and help you, support you in those conversations. But I would always, you can always direct those to your directors, and then they can talk to the other agencies to kind of explain and see what we can do. Sometimes if you talk to the client and say, hey, somebody's here, do you want to see them? That kind of stuff, but you can't disclose that the person is in there without a release of information to other agencies when they come in. Even if the police are sitting outside and see that person walking in, you can't tell them who they are or that they're there unless the client's okay with it or there's a release. Next slide. So penalties for releasing information with malice intent. So knowing or wrongfully disclosing information, receiving information, a protected health information can be a $50,000 fine and or up to 1 year in prison. If you commit the offense under false pretenses, meaning like if I call and say, hey, I pose as a client, and then the information is released to me, I can be charged and fined up to $100,000 fine and up to 5 years in prison. And then if you, with the intent to sell protected health information or client list for personal gain or malicious harm, it's a $250,000 fine and or up to 10 years in prison. So they take it really serious with confidentiality. And so next slide. So what would be some consequences if we violate confidentiality? Like, how would that affect our licenses? How would that affect our agency? What would be some of the consequences for those?
Yeah, licenses can be suspended, yeah.
We could. Mm-hmm.
Termination. Oh, sorry.
Also,
yes.
People would cease to trust us.
Yes. Because if you're a mental health facility and information gets out that we provide and we disclose information, nobody's going to want to come and get treatment. Nobody will come to us. People will lose trust and respect in our agency. It can affect our licensure. It can, where people can be terminated from their employment. And so confidentiality is very strict and is taken very, very seriously. Next slide. So other consequences of break into confidentiality would be public embarrassment, feelings of guilt and shame, personal effects on your credentials in the community. And so if you're uncomfortable in saying information in a well-lit room of your peers, then you should seek supervision before you do. So this is how I always look at it. Like, you can't unring a bell. So if It's better to provide little information than all the information. You can always go back, like if you provide just a little bit of information that's covered and you're not really sure how much more you can share and somebody's mad because you're not sharing more information, that's okay. If you need to share, or if there's things in place where you can share more information, you can always do that, but you can't ever unshare information. So like in your emails, when you send an email, there's a delay, and I always go into my email and I've told my staff this, and I've trained this on other HIPAA trainings, is that you can go into settings and you can change that delay to 30 seconds, because sometimes our emails just, if you get in a hurry, and our emails will just put up, like if you start to type in a name and it automatically autofills. Well, if you have two people in your email that have the same name and you're not paying attention to the email that's being sent, and it gets sent to the wrong person, and you're like, as soon as you hit send, you're like, oh my gosh, I didn't mean to send that. If you go down, if you set it for 30-second delay, you can go down in the left-hand corner and you can undo it and it will unsend it. But once an email is sent, it's sent and you can't bring it back. And so those things do happen by mistake. And so if those things happen, you have to let Kara know, because we have to let Medicaid know. And so you always want to make sure when you're sending emails and stuff, you're not sending personal information. Like if you just send the client's number, if you accidentally send it to somebody else and there's no other identifying information, you're probably okay. But if you put the client's name or birth date or the substance use treatment or things like that, it can put you in a really difficult situation if it goes to somebody that wasn't intended for. Does that make sense? So in today's society, oh, sorry, Kara, next slide. In today's society, we sign so many forms that we tend to just sign whatever is in front of us. Usually we never read what we are signing. For our clients, they may feel pressured into signing an ROI. It is important that they give informed consent, meaning that they understand what it is they are signing. This is particularly important with our clients with a thought disorder or paranoia. So if we're giving our clients releases of information to sign, we want to make sure that they understand what they are releasing and what information this other people, other agencies can receive. So you have the right to encourage a client not to sign a release if they feel it would be detrimental to the progress of the client or well-being. And the client needs to understand what they're signing. So I would, as a therapist or somebody that's helping somebody fill out ROIs, you want to go through it and make sure that they understand what they're signing. With our credible system, like DCFS, they are asking for, that's kind of my frame of reference because that's where I worked. But so if they call and ask for assessments on clients, which they do on a very consistent basis, if we have this client in our program prior to the release being signed, like a year before, and then they come back in and they have to do an updated assessment, generally we clone those assessments. So all that information prior to the date of the release is not covered by that release of information. And so you always want to put any and all information. And I always explain to my clients, so all this information prior to the release being signed, this is what they're going to get. They're going to get the entire assessment that has been with us since you began services. And if they don't want that, then you'll have to adjust that. But I always want to let them know that that's in there. And then you always want to put any and other information. So if a client comes in on January 1st to do an assessment and they don't sign the release until January 5th, you can't release that information because it was prior to the date of the release signed. So you always want to make sure that you're looking at the dates as well. And then if you put any and all information, then that should be covered. But you always want to talk to the clients and let them know that that's the information that will be going out. Next slide.
How long is a release of information paper, how long is that good for?
So it lasts for as long as the client's in services unless they rescind it. So if they come in and they say, I don't want DCFS or APMP to have access to my records anymore, then they rescind it, and then it would be documented in Credible. The support staff will put in there that it's been rescinded and it's no longer valid. Once the chart's closed, I can't remember if it's up to 30 days or 60 days. Do you remember, Kara?
The what? Sorry.
That once the chart is closed, how long the release is still in effect? Is it up to 30 days? I can't remember.
If it's closed, isn't it a year?
It might be. Let me look really quickly.
If they don't revoke the release before they close, before the case is closed, I think it's good for up to a year.
I think you might be correct. Let's see.
I'm not sure though.
Let's see. So in our releases of information at the bottom, it says, I may take back this consent at any time in writing. The release to share information automatically expires 1 year after my discharge date from Four Corners Mental Health, unless I choose a different date or event or condition when it should expire. And then there's a line where you can write the date. With the signed release of information, we may share information on that consent. One cannot take back consent to share information already shared with earlier consent. Information released with consent must be protected by federal law and may not be shared to a third party except as provided by law. So your rights about how we use and share your protected health information are in the notice of privacy practices. So it is 1 year. So you don't want to share patient information unless it's legitimate business or patient care purposes. You don't want to share passwords or PINs. Don't place patient information in garbage cans unless it's shredded. Don't leave documents containing protected health information anywhere. And don't release anything you wouldn't want released yourself. It is clear that the public is very concerned about their privacy. If you respect the privacy of your patients, they will continue to use your services. The healthcare profession is based on the premise of cause no harm, and protected health information is sensitive and can cause unforeseen consequences in the hands of the wrong people. It can impact employment decisions, cause embarrassment, and have negative impact in personal relationships and social interactions. Next slide. So do limit the sharing of protected health information by taking precautions such as not having conversations about a client or patient in public areas that can be overheard by others, including telephone conversations. Do keep the information secure, so lock your office, limit the access of areas where the protected health information is stored, and shut down or lock down your computer terminal when unattended or not in use. So if you're like with your computers and stuff like the front staff, you always want to make sure that that your computer is not facing where somebody out in the lobby can see, and you want to keep it secure that way. Examples of administrative procedures are routines and procedures to ensure that information is maintained and kept up to date. This would include an organization's security policies, sanction policies, and formal authorizations, and formal security training programs, which is your credible system and the new employee orientation. Examples of physical safeguards would be restricted to entry to working areas where information is processed and stored, locked doors or files, drawers where protected health information is kept, physical safeguards for systems and facilities from environmental hazards and from intrusion, technical safeguards against unauthorized access to data that is in electronic form, such as passwords, role-based access, and encryption. So next slide. And so when we send out emails, there's the virtue that makes it encrypted. So when you're sending out emails, you always want to, about information, you always want to make sure that the virtue is on and that it's encrypted. So then the person intended to get that would have to put in a password and would be able to get that information. So go on, email that confidential information with no encryption. What can go wrong? Next slide. So I kind of get ahead of myself sometimes, but electronic safeguards, computer terminals should be positioned to not allow unauthorized view from doors, windows, or front office terminals. Use minimal patient information when included in an email. So you just want to send the credible ID or the first couple initials of the first name and the last name, no other identifying information, no birth dates, no programs they're in, no demographics, none of that. Fax machines that send or receive patient information must be located in a secure area. We don't use fax machines as often anymore, but we still use them. So you want to make sure that you're verifying the fax number before you send the information. You ask if the fax machine is located in a secure area, and use the fax cover sheet that contains a confidentiality note. So when I was working at DCFS, whenever I would call for information, they would always, and we're DCFS was protected by HIPAA as well, but they always ask me, is your fax machine secure? Every phone call that they had with me, just to make sure that everything is, that we're following all the policies and protocols. Next slide. Special attention should be given to any portable device that contains patient information. So laptops should never be left unattended in cars. They're required to be password protected and the database encrypted. So if your laptop, if you walk into like if you get gas and you walk into the gas station and you left your laptop sitting on your front seat, and I don't always lock my doors when I walk in to pay for gas. Somebody can walk by, grab your laptop, and you would not even know who it was. So you never want to leave your laptop or anything in your car unattended. You don't want to save information on jump drives, cell phones, or any device that someone could gain unauthorized access to. And you don't want to save passwords on any portable devices. Next slide. So when you're texting, because texting is kind of the wave of the future, I think people text more than they talk anymore. So things to think about is, how is that text reflected in the patient record? And is it secure? So if you're texting about a client, is it secure if somebody gets your phone? Because like my phone's not encrypted because it belongs to me. And so if somebody happened to get my phone, they may be able to get into it and get all that information. So you never want to you want to text as little amount of information about a client as possible. And then can you provide the patient with access to the text records? So say that there's information on your phone that has information about a client that they request a grandma request any and all information, that they may be able to receive access to your phone. And if they can, that means the entire phone, not just the specific text. They can get access to your phone. Like if it's a court hearing, they can see pictures, whatever's on your phone. So to protect you as well, you always want to make sure that limited information. And sometimes if they're text information, if you're texting about two different clients, then they would have access, and then that would be another breach because you would have two different clients in one text. And then does a record reveal information about other patients or personal provider information? And is there any way to know what protective health information is on a phone if it's lost or stolen? So like I'll have somebody call in or text me and say, if they're in the middle of like hospitalization, they'll text me client such and such, they'll put the number is going to be hospitalized, and then I'll say approve, and then I delete the text after that. They document it that in their note that they've talked to me and it's been approved. But anything that's like that, I just delete it because it's if my phone gets stolen, then I don't want that information on there. So never text a client's full name if they're identified as a client. If you receive such protective health information from someone else, perhaps from a partner agency, reply with the protected health information or name put in deleted, and tell the text recipient that you have deleted the name or other protected health information because you must comply with HIPAA rules. If a client wants to talk about treatment, switch to a phone call. Don't text with clients. You do not know if someone has picked up their friend's phone and might be reading someone else's text messages, and document your phone outreach incredible. And so, and does anybody have any questions about that? Okay, next slide. And this is just a little cartoon, taking selfies and then having the computer in the background. Okay, next slide. So electronic communication. So Facebook, everybody's on Facebook, social media, texting, all of that stuff. So personal communication with clients should be avoided using technology such as social networking sites, online chat, email, text messages, telephone, and video for personal or non-work related purposes. And it's actually in the NSWA's ethics is that therapists and they cannot be friends with clients with active clients. It's an ethical violation, and it's in the ethics, but it's in the ethics document. And so I always let my clients know as well that, if you see me on Facebook or stuff and you send me a friend request, I'm unable to accept that friend request because it crosses the boundaries. because you always want to keep that boundary there between you and your clients. And so that way, if they send me a firm request and I don't respond, they don't get their feelings hurt, they're not upset, they're not, feel like I don't like them, those kinds of things. So I always let them know up front that I wouldn't be able to if that is an issue, if that may become an issue. I don't do that with every client, but if there's some clients that I feel like it might be kind of an issue, then I always discuss that with them. Because I've had clients friend request me and I never respond. I just delete the request and I talk to them about it, so they don't feel upset or hurt that I didn't accept it. Next slide. So how can we be helpful and still keep our clients' privacy? So just listening to someone and allowing them a space to talk about their concerns helps calm them and allows them to feel validated. So we can listen, we can give broad guidance, not specific information, because we don't want to make it specific about the person somebody's maybe talking about. But we can refer parents and family members to Al-Anon or other support groups. We can offer naloxone kits. We can refer them to NAMI, suicide hotlines, websites for more information about mental health, or the National Suicide Hotline. And there's also the 988 number besides. And so if somebody calls and like, I'm really concerned about my child, my spouse, whatever, just give broad guidance. Like generally this is how things handle. Somebody would come in, they would fill out an intake information. We would schedule just kind of like the general workings of stuff, not specific. So you want to be broad with your guidance, so it doesn't come across that you're giving specific information about a particular person. Next slide. So there's oversight exceptions. So Medicaid and the Department of Substance Use and Mental Health are oversight agencies and do not need patient authorization to receive protective health information for oversight activities that are authorized by law. So we have audits and stuff that come from Medicaid, and they look at our charts. We don't have to have the law allows them to look. We don't have to have releases of information by the clients for them to look. So the CFR 164-512 allows to collect or receive information for the purpose of preventing or controlling disease, injury, or disability, and the conduct of public health surveillance, public health investigations, and public health interventions. Utah Code 62A-15-103 refers to reporting on public funds and program use. So they're allowed to look at our charts to make sure that we're following the laws and the regulations of the public funds that we're using and those kinds of things. Next slide. So if you have any questions or need guidance with confidentiality, 42 CFR, HIPAA, you can talk to our supervisor. You can contact Kara, who's the compliance officer, or where she's a clinical director, or any member of your executive committee. Does anybody have any questions?
I don't think so, Michelle.
Because I know HIPAA is the most exciting part of your training.